with the Supreme Court striking down the Feb 12th circular of the Reserve Bank of India, a circular that had looked to revamp the manner in which banks deal with stressed assets. The circular had asked banks to start working a resolution plan for accounts of over 2,000 crore rupees immediately on default and finalize it within 180 days. The circular said if not done, the account would have to be referred for insolvency proceedings under the Insolvency and Bankruptcy Act. The Feb circular had also discontinued existing restructuring scheme, whether it's corporate debt restructuring, SDR, S4A. It was a very controversial circular, and one wing of the government, the Power Ministry, is the first one to have moved court, the Allahabad High Court. I believe RBI Board member, Professor Sachin Chaturvedi, is joining us on the phone line to talk about this. This is a big ET Now exclusive, a board member of the Reserve Bank of India on ET Now to tell us what happens next. Thank you, sir, for joining us here on ET Now. You know, the Supreme Court quashing this controversial Feb 12th circular. All the experts are confused. What happens next? What is this going to mean for the Insolvency and Bankruptcy Code? And more importantly, will we see the RBI perhaps file a review petition?
I think that would be very, very important. As you may recall, during those stormy RBI board meetings, we had a lot of discussions in terms of the viability of such a circular across the legislative frameworks. And today, the Supreme Court's decision is absolutely clear in terms of how we go forward. Two things here are important. One, that the circular asks companies with borrowings of more than 2,000 crores to have a window of only 180 days to be deferred to NCLT. And second, which I think was absolutely important, was to do away with the extent debt resolution mechanisms like CDR and SDR. So that, I think, in my view, could have been avoided at the outset. And this, if you look at the debt profile, you find that almost 100 top borrower firms, they account for around 21% of gross NPA. And on my own research institute, we did a study to see top 100 Indian firms, if you see, they are landing up in the global market to mobilize resources. So this is something when India has huge savings, why we cannot provide long-term commitment for our own companies. So irrespective of the what steps RBI would take now and what steps government would take, I think it's important for us as a country to see that the companies that are investing in long gestation periods, particularly with this judgment, the power, the sugar, the fertilizer sectors, the unorganized sectors would be affected, for which the projects have a long gestation period. So you require development financing mechanism which can really bring in the long-term commitment, and 2.2 lakh crores here is at stake with this. So in my view, we require as a country a solution in terms of how we move forward. But particularly in this case, there were already a lot of issues being discussed at the RBI board and even outside, which media has been reporting.
So, sir, from what you are then saying, was the RBI board not unanimous with this Feb 12 circular? That seems to be the indication if your own research has shown that the circular could have avoided a few of the controversies, for example, doing away with the SDR, CDR, etc.
Actually, if you recall, ET Now had reported about this almost two months back after the November meeting of the board. And there were discussions, and I cannot reveal what was discussed in the board, but definitely a lot of stories at that point tumbled out in different points, and I think it was very widely reported.
But I also now want to understand, sir, that what is this going to mean for NPAs, for breaking bad debt, for the cleanup of banks? With this judgment, does it mean that, once again, all the NPAs and the promoters can start relying on instruments and mechanisms like SDR, CDR, as that come into effect? Would that be your understanding of the judgment? And what is this going to mean for the Insolvency and Bankruptcy Court? Will this now not delay resolution? That 180-day deadline is no longer going to be sacrosanct?
See, there can be no doubt about the fact that you require discipline in the banking sector. The RBI was right in terms of bringing in reforms, and we need to see that at the same time, government has also come up with IBC, and a genuine commitment for bankruptcy reforms is coming up. But we need to also distinguish here and nuance it better whether a generic circular of this nature could have been avoided. So we need to see how now we move forward. There can be no doubt that you require the public sector banks to be insulated from getting into the NPAs and the huge challenge that we have landed up with. But at the same time, we have to give industry the necessary support that requires them to steer through the wider global challenges and recessionary trends that you see in China, and now Germany is not far. So we are realizing that in several European countries and in many other competitor countries for us, we are seeing. You have connected me in Cape Town, where I'm attending the New Development Bank's board meeting, and we are realizing here how the challenge of the recession is right up front for several countries. So in that context, we need to be considerate in terms of the firms which are facing genuine problems and those who are making up for the bad debt. So how do you distinguish? And that's where the flexibility and the better mechanism of the public sector banks and the concerned provider would have to come in. But RBI as a overarching framework would have to see that sui generis model by the public sector banks is something which is efficacious and effective.
So, can you explain to us, because I think there's so much confusion about what's going to happen to resolution. So, while you are in Germany and you're studying various European procedures as well, the Indian situation is, of course, very unique too. What happens? Because, there are also cases of the Insolvency and Bankruptcy Code under Section 29A not allowing related parties and promoters to bid for the assets. Now with, Feb 12th circular gone, is it also a backdoor entry that will be given to promoters, you think? Because Insolvency and Bankruptcy Code can be avoided altogether. And you on the board of RBI, sir, seem to be in favor of that. You seem to be in favor of giving the promoters an opportunity, of giving the companies one more chance.
I'm not saying that. What I'm saying is that let the banks take a call, which would have to be done at the micro level, which a generic circular cannot manage. It has to be done. It has to be tailor-made to specific firms and specific actors because they are the borrowers. So the banks would have onus to ensure that they do not end up with NPAs. But a generic circular would stifle the economic growth that we are expecting, the industrial production expansion that we are looking at. And given the global context, it is all the more pertinent on part of the public sector banks to exercise that caution. And we need not get into that micromanagement through generic circulars. The concerned banks would have to take that call.
Sir, is it also correct to infer that all the cases at the NCLT that were under the circular of Feb 12 will now stand withdrawn? We don't know the fate of that resolution of all of those assets. I understand 75 companies, 2.24 lakh crore rupees hangs in the balance.
I think we would have to wait and see the detailed judgment. I haven't seen it, only the initial news that is coming in. But I think we would have to wait and see how the interpretations are and in what way legal interpretation would enable companies to get out of NCLT or the concerned banks. But as you understand, the issues are in terms of strengthening the mechanism rather than weakening it without adversely affecting the growth prospects. Thank you.
So just my one last question, could there be a domino effect, cases which are not under under February 12th circular, the big cases, whether it's an SR Steel, Bhushan, you name it, the first RBI list, the second RBI list, could that come under threat? Could there be a domino effect? Could there be a spillover effect?
I think one point which is absolutely clear is in terms of avoiding any generic sort of solution to the whole problem. We would, as I'm saying time and again, it's important that we get in at the micro level and see how individual banks are going to address that. And that, in my view, would be extremely important.
Okay, with that we'll thank you, sir. I know you're out of time. You joined us from overseas. We really appreciate you joining us here to help us understand that Supreme Court verdict, the road ahead. So it seems as if, and we've been talking about this, it was a stormy affair, that board meet for the Feb 12th circular. The entire board was never on board, literally, for removing mechanisms like CDR, SDR, S4A. So let's see how this one pans out. But one board member also saying there should be no spillover impact on this. Right, so that's as far as the Feb 12th circular reportage goes. We brought you up to speed